Thank you. So in this presentation on the destruction and retention of medical records, I'll be addressing the overarching theme of the difficulties that infected individuals and their affected family members have had in obtaining medical records. The presentation does not seek to answer individual circumstances of missing or destroyed records. Instead, it identifies and tries to address key themes that arise. There are 4 themes: NHS retention and destruction policies, examples of environmental destruction of medical records, such as by fire and flood. Thirdly, the difficulties infected individuals and their affected family members have had in applying for records, including themes of delay and the impact of missing records. And finally, I will consider examples of significant interference in medical records and evidence as to whether there has been intentional destruction or removal of medical records. Before I explore those 4 themes, it's perhaps worth simply noting that the difficulties in obtaining records means that individuals do not have a complete picture of the medical treatment that they or a family member have received. And the absence of an official record of what has happened can make it difficult to ascertain how, where, and when a person was infected with bloodborne viruses. So I know that's something that you're very familiar with. The inquiry has also heard evidence that the lack of access to a complete set of medical records has meant that many individuals have been unable to access financial assistance from the schemes or have had to go through lengthy appeal processes in order to attempt to prove the source of their infection. The inquiry has also heard from a number of witnesses about how challenging it's been for many patients to obtain records. There was and remains no central system where medical records are held, and individuals have to apply to specific NHS trusts, health boards, or GP practices. It goes without saying that that can be particularly challenging for those with haemophilia who've received treatment over a number of years from a number of hospitals, particularly if they have moved around the country. Similarly, for those who've received transfusions, a number of witnesses identified that they received transfusions in hospitals, particularly maternity hospitals, that have long since closed down, and medical records have been destroyed without prior notification to patients. To give the presentation some human context, one woman describes trying to obtain her late father's medical records as like a battle of wills. She describes applying to a variety of organisations and 7 different hospital trusts, chasing them up and asking them to look in specific departments and archives, and sometimes having to complain. Another affected daughter describes attempting to obtain her mother's records in the following terms: "We struggled to find someone who could assist us. At one point I called every day, but often no one would call me back. Eventually, we received a letter saying that the records were no longer available and they could not help us. When we inquired further, we were given different reasons for this, including that the records had been destroyed in a fire and that they did not retain records for that long." Many witnesses have commented that when they have received medical records, they've been provided in a muddled and unchronological order. The difficulties of reading through and understanding unsorted and unpaginated records has been highlighted by several witnesses, made more challenging where records are also partial, and the witness has then struggled to identify what records are in fact missing within the mass of records they've received. Some infected individuals and their affected family members whose medical records have been destroyed have queried whether there's been a cover-up and or a purposeful destruction of medical records in order to hide evidence and avoid a finding of fault against clinicians. The inquiries investigated a number of these concerns and approached individual trusts, health boards and social care trusts in order to obtain an explanation as to why medical records have been destroyed. In the main, it has been difficult for the inquiry to obtain sufficient evidence to enable these conflicts to be resolved due to the passage of time and the absence of clear evidence documenting why, when and how medical records were destroyed.
May I just ask, is there a problem when records are actually obtained in interpreting what they're saying?
Towards the end of the presentation, I think in my third theme, I will address some of the challenges of once records have been obtained in terms of legibility and the content of them, whether they're accurate or not. Certainly across many of the statements the inquiry has received, there are also concerns about understanding what's been written, both from a legibility perspective and understanding what's been said.
Yes.
Taking the first theme then of retention and destruction policies. In this part of the presentation, I will address the legislative provisions about the retention and destruction of medical records. From there, I will set out the policies of a sample of individual NHS trusts and health boards that the inquiry has obtained. For, I hope, obvious reasons, sir, it is a sample of trusts and boards. It couldn't possibly be for every trust and board across the whole of the country.
Well, it could be, but it'd take us far too long.
It could be, but indeed. Thank you, sir. I'll then look at the evidence that's been obtained from some clinicians about local practices and policies on record keeping, and I'll complete this first theme by looking at some examples from infected individuals and their affected family members in relation to medical records being destroyed under retention and destruction policies. Now, as I work through the legislative frameworks in the 4 countries that make up the UK, it should be borne in mind that the law dealing with the retention and destruction of medical records sits within a wider legal framework, so that I'm aware you're very familiar with, that addresses a range of important issues, including the right to access health records, the requirement to keep clear, accurate and legible records, the requirement to keep certain information confidential and to abide by data protection laws, and of course freedom of information. Those issues are beyond the scope of the presentation. Starting with the position in England, the Public Records Act 1958, as amended by the Public Records Act 1967, is the principal piece of legislation relating to public records. Records of NHS organisations are public records. The Secretary of State for Health and Social Care and all NHS organisations have a duty under the Act to make arrangements for the safekeeping and disposal of all types of records. The Act gives NHS staff authority to destroy records in accordance with an approved retention and disposal schedule. That schedule is found in the Circular HM 6173, and if we can turn to that, DHSC 0050744, please. We can see in the top right corner the HM reference and the heading, Preservation and Destruction of Hospital Records. The summary says this memorandum advises hospital authorities of the changed arrangements for disposal of hospital records following the Public Records Act 1958, and it replaces a previous circular. Towards the middle of the page, we have the heading Selection and Disposal of Records. The schedule transmitted with HM 56103, authorising the destruction of various types of records, is superseded. In its place, the lists contained in Appendices A and B below, drawn up in consultation with the Public Record Office, should be observed as the guide for selection and disposal of hospital records. Appendix A lists classes which should not be destroyed at all. Appendix B lists those which may be destroyed. If we then turn the page, we pick up in paragraph 8 something that arose yesterday with Professor Armstrong in relation to microfilming, and I will pick that up through the documents as it crops up. Paragraphs 12 and 13 of the previous circular, HM 5447, referred to the microfilming of medical records regarding hospital records in general. The note to the former schedule indicated that any document of which the schedule authorised the eventual destruction might be microfilmed after 2 years, the original then being destroyed and the microfilm retained for at least the remainder of the authorised retention period. The finding of the Committee on Departmental Records, after careful investigation of the use of microphotography for archival purposes, was that the high overall cost of reproduction of records on microfilm would be much more than the cost of providing storage accommodation for the original documents. In view of this conclusion and of other disadvantages mentioned in that committee's report, microfilming is not now recommended as a method of reducing the bulk of documents held. If documents have been selected for permanent preservation, the original documents must be preserved. It's not permissible to preserve microfilm copies in their place. If we then turn to page 9 of the document, we pick up the Appendix B that was referred to, and we see halfway down the page the heading Part 4, Medical, and we have the retention and destruction periods, the period after which documents may be destroyed. And we see at 24, blood transfusion service, laboratory records relating to donors, 1 year after the resignation or death of the donor. Medical records and allied documents in hospitals. Medical records including clinical notes, which includes reports from pathological, radiological and other special departments, X-rays, electrocardiographic and electroencephalographic records, blood transfusion records, consent forms of all types and 4-hourly temperature charts. They are given the period of 6 years after conclusion of treatment or where the patient dies in hospital, 3 years after death. Going down a little further, operation books is the 6 years from the date of the last entry, as are casualty notes. Day and night nursing report books, 6 years from the date of the last entry. That could come down now. Thank you, Lawrence.
It gives rise, the question of 25, hospital records, identifying when the conclusion of treatment is.
Indeed, sir, and I'm sure that somebody behind me will correct me if I'm wrong, but working through all the documents for this presentation, we haven't been able to identify any indication of what that meant or any guidance as to what conclusion of treatment meant.
So someone who is not discharged from the care of a consultant, let us suppose, would presumably still be having potentially treatment.
It's difficult to say, sir. There's simply no guidance. No.
And we don't know if ongoing treatment such as diabetes, haemophilia, whether that ever finishes.
Indeed, and that was one of the matters canvassed with Professor Armstrong yesterday, of the difficulties in relation to chronic conditions where treatment continues at home, whether there's a conclusion of treatment at the hospital or not.
Yes. Yes, thank you.
An article published in 1985 in the Journal of the Society of Archivists observed that the circular appeared to take a very narrow view of what was worth preserving. So around the time, in 1985, there was a concern about the narrowness that had been taken. In 1980, the Department of Health and Social Services issued further guidance on this issue, DHSC 0105700, please. We see the heading, retention of personal health records, open brackets, for possible use in litigation, and the summary explains this circular recommends new minimum periods of retention for personal health records, other than records, excuse me, other than records held by family practitioner committees, to take account of the provisions of the Limitation Act 1975 and the Congenital Disabilities Civil Liability Act 1976. So obviously the Act dealing with matters of litigation. If we go towards the bottom of the page, we pick up the heading Minimum Periods of Retention for Personal Health Records. Personal health records may now be required as evidence in legal actions for considerably longer than hitherto. This circular suggests new minimum retention periods which might suffice for this purpose. The Department's advice is that the minimum periods proposed are likely to be regarded as acceptable by the courts. The actual periods for which records are retained will depend upon a number of factors. See paragraph 6. And if we turn the page, special considerations apply to records relating to children, young people and mentally disordered people, as they were at that time described. In most other cases, a person or his representatives might be expected to know whether he has a cause of action within 5 years of the alleged negligence, from which time the limitation period should be taken to run. It is recommended that the following minimum retention periods should be observed. Obstetric records, 25 years. Records relating to children and young people, including paediatric, vaccination and community child health service records, until the patient's 25th birthday or 8 years after the last entry, if longer. And then there's the reference to the Mental Health Act. And then this, except that such records need only be retained for a minimum of 8 years after the death of a patient, or in the case of obstetric records, death of the child, but not of the mother. All other personal health records, 8 years after the conclusion of treatment. And then under the heading Actual Period of Retention of Personal Health Records, it records, subject to the minimum periods proposed, it is for health authorities to decide on actual periods of retention, having regard to the wishes of individual consultants with responsibility for the cases in question, the requirements of research and the responsibilities of authorities under the Public Records Act, as well as to implications for litigation. That was in 1980. In 1981, the Lord Chancellor established the Wilson Committee to advise on the retention of public records, and the committee reported in March 1982. DHSC 0105702, please. We see the heading Modern Public Records, Selection and Access Report of a Committee appointed by the Lord Chancellor. And then if we turn to page 5, paragraph 384, it's not surprising that after about 20 years, the hospital circular, that's referring to the circular we looked at it from the 1960s, the hospital circular is out of date, and we have consulted DHSS about its replacement. The department recognise that as part of their general statutory responsibility for health authorities, national guidance on criteria for the selection of records might usefully be drawn up to replace out-of-date guidance. As it stands at present, they regard it as doing little more than drawing the attention of NHS authorities to the requirements of the Public Records Acts. Attempts to update or strengthen detailed guidance have, however, not been successful. The NHS authorities have in the main been averse to diverting scarce resources to records, and DHSS were reluctant to appear to direct them to do so. Then the next paragraph. This highlights one of the other major gaps in the present arrangements. Such central guidance as there is on the preservation and destruction of NHS records is not backed up by any specific guidance on resources. The initial inclusion of NHS records within the scope of the 1958 Public Records Act and the subsequent issue of central guidance affirms a policy decision to treat them as public records that would logically imply an intention to supply the means of implementation. In practice, however, DHSS has no, or only limited, powers of detailed direction over health authorities' allocation of the total resources available to them. These resources are never sufficient for all needs. It's therefore scarcely surprising, however regrettable, that the proper selection and storage of records has had a very low priority in the eyes of most of the regional authorities. This has meant not only a lack of uniformity of practice, but on occasion the unselective destruction of records in the face of a shortage of storage space. These problems may well be aggravated by the further reorganisation of health authorities which lies ahead. If we can turn then to page 14 to identify the recommendations of that committee, and its recommendations at paragraphs 413 and 414 that are particularly relevant. We recommend that the NHS should designate a specified record officer for each region to take responsibility for the general supervision and handling of its records. He should transmit the DHSS guidance and that of the advisory panel to individual organisations and hospitals, and see that selection and transfer requirements are carried out. We recommend that the specified record officers should take steps to have locations for each region designated as places of deposit for clinical records appointed by the Lord Chancellor. The government responded with a white paper rejecting the recommendations concerning clinical records, but accepting that the guidance needed to be revised. I'm about to move on to 1985, sir. I wonder, given the time, whether we should break for lunch there.
Yes, well, we'll come back to 1985 at 2:05. 2:05.